Hello and good evening, everyone. I'm back with another important topic from family law, that is ceremonies concerning Hindu marriage and the issue of registration. On behalf of Live Law Academy, I welcome everybody. And on that note, let me just share my screen. Today, we'll be discussing many important aspects relating to ceremonies and registration with some of the very important cases. But but any discussion on ceremonies and registration will be incomplete without first understanding the nature of Hindu marriage itself. So I'll be discussing with you the nature of Hindu marriage as it is reflected in some religious texts and the way we have the Hindu society have understood it. So Hindu marriage, it is said that it is a sacred commitment having deep roots in our culture and in our social lives. It is a combination of both spiritual and social values, and it is a bond that transcends several lifetimes. In ancient texts, they indicate that Hindu marriage is not only a connection of bodies, of two bodies, it is also a connection of two souls. And this connection, it is believed that this connection continues beyond a particular lifetime. It continues after the life, it continues in the new births, even after death, right? So that is why we see people saying that marriage is what? Marriage is जन्म जन्मांतर का संबंध, right? A bond that transcends several lifetimes, as I just mentioned. Then Hindu marriage is also connected with the deaths. Let me show you how. Veds, we have four Veds under Hindu law, right? These Veds, they indicate that every Hindu who is born in this world is indebted in three ways. He is indebted to the sages, that is called Rishi Rin. He is also indebted to the gods, and this debt is called Dev Rin, and is also indebted to the ancestors, and this debt is called Pitri Rin. Right now, marriage becomes very important as an institution because it is believed that marriage enables a person to satisfy, to fulfill these obligations, especially the debt towards the ancestors, right? Because marriage leads to procreation, right? Marriage, one of the essential functions of marriage in the society is to let people procreate, and that procreation, it ensures that the family lineage, it continues, right? So if the family lineage gets continued, debt towards the ancestors is satisfied because the Hindus, they view life in a cyclic form, in the sense that if a particular person is not able to satisfy all the obligations that God intends them to satisfy, and it is also believed that you carry certain things from your previous birth to the next birth, right? So that sort of balance has to be maintained, right? That account is maintained by the spiritual being. So you have to satisfy all these things, and in order to satisfy that, if you're not able to do it in a particular lifetime, another chance is given to you, and in order to avail that chance, there is a necessity that the family lineage must have continued, because then you will be taking a rebirth in the same family, right? That is the belief system on which the Hindu law is based. So that is why marriage as an institution becomes very important, because it lets you to procreate, and procreation helps in continuation of the family lineage, and continuation of family lineage allows you to fulfill these obligations, particularly the debt towards the ancestors, right? Uh, it is also believed that the wife is not only a partner in material life, in domestic life, she is also a supportive pillar in spiritual life, in the spiritual sense. That is why some of the texts they refer to wife as Sahadharmini, that is, co-participant in the acts of dharma. So it is believed under Hindu philosophy that a husband performing religious rites and ceremonies in the absence of wife, or a person who is not married and he performs such religious rites and ceremonies, these ceremonies will not give 100% of the outcome that is actually intended, right? So you need a wife beside you. You need a wife to support you in these rites and ceremonies, so that the spiritual benefits can be completely derived out of them. Any offerings made to the god uh, without wife, or in the absence of wife, right? That offering is not accepted by the god, it is believed. And on the same lines, we have an observation made by Mr. William Herman. He has written a paper titled as The Hindu Marriage as a Soteriological Event. This is published in the year 1987 in the International Journal of Sociology of the Family. So the word soteriological, it refers to a belief system where people actually believe in the concept of rebirth and salvation, and fulfilling your obligations to achieve that state, right? So he mentions that Hindu marriage is considered to be an event that confers salvation upon the individual, especially when the rites and ceremonies are conducted. So here, William Herman is making actually two very important observations. One observation is with respect to the nature of the marriage, that it confers salvation. This we have understood already, right? Then he is also talking about the essence of rites and ceremonies in performance of such marriage, right? Especially when he puts an emphasis on this, especially when the rites and ceremonies are conducted. So, rites and ceremonies they become very important. Having understood the nature of Hindu marriage, now we can actually move on to the main topic, that is ceremonies. Firstly, I'll be talking about the ceremonies in general, and then we will move on to the provisions of Hindu Marriage Act. So, under traditional Hindu law, it prescribes various ceremonies related to marriage, and out of those ceremonies, some are essential, while others are not given the same treatment. And the non-essential ceremonies relating to marriage, we see that there is a great amount of variations in case of such ceremonies, right? So broadly, you can classify the ceremonies as essentials and non-essentials. Essential ceremonies, they are mandatory ceremonies, whereas with respect to non-essential ones, we see that the overall Hindu society it observes it with some variations, right? However, some of the important ceremonies, and with these ceremonies, most of us can relate to. Either we have gone through these ceremonies ourselves, or we have seen other people to perform the same, right? So, some of the important ceremonies I have highlighted here for you. The first one is Sampradhan. Sampradhan. It refers to the ritual when the husband comes to the location where marriage is to take place. Nowadays, it can be a hotel, banquet, etc. Earlier, it used to be the uh, house of the bride, right? So when a bridegroom arrives along with the procession that supports him, and that is with him, and when he arrives, water is offered to him to clean his feet and his hands, and after he cleans them, another mixture of water along with honey and flowers and rice. They are offered to him with some chantings, right? That is for the purpose of making a holy entrance into the premises. Then, obviously, we have the ceremony of Kanyadan. It is one ceremony with which we are acquainted with, that we have seen this happening in movies. We have seen this in happening in marriages that have taken place around us, right? So, in this ceremony, the father of the bride, he promises that now he allows the bride to get married with the bridegroom, and he takes some promises from the bridegroom. He asks that the bridegroom should not cheat or make falsified claims in the matters of dharma, arth, and karma. These three are the important pillars of Hindu law. They are seen as the objectives to lead a meaningful life. So, in the matters of dharma, arth, and karma, the bridegroom promises the father of the bride that he will not make any mistakes, and he will uh, ensure that equality is maintained between them in terms of these three things. Right? Then we have Vivahum. It refers to the sacred fire that is lit, and this sacred fire is believed that it actually witnesses the marriage taking place, and then there are offerings that are made to the fire. That is called Vivahum. Then we have the ceremony of Pani Grahan. Pani Grahan, it is not at all related with water. Uh, it is actually the groom holding the hand of the bride. That ceremony is called Pani Grahan. Then we have Agni Parinayana. This refers to the movement of the bride and the groom in a circular motion, uh, having the sacred fire in between, right? So the groom, he comes at the front and bride accompanies him. They complete several rounds in circular motion, and the mantras are chanted. That ceremony is called Parinayan. Then we have Saptpadi, and this Saptpadi uh, you'll find reference of Saptpadi in section number 7 also, that we'll be examining just after this. Right, Saptpadi refers to taking of 7 steps, and after completing the seventh step, the marriage actually becomes final. Nobody can now take a step back from it. And upon completing Saptapadi, the bride who was initially sitting or standing on the right side of the groom, she comes to the left side of the groom after the Saptapadi. This is an indication that the ceremonies between them have now been completed, and now she has finally taken the place of the wife of the person. Right? But now we need to examine what is the position with respect to ceremonies under the Hindu Marriage Act. For this, the important sections are section number 5 and section number 7, 7 in particular, because section 5 merely tells you the conditions for valid Hindu marriage. It nowhere talks about ceremonies. It lays down conditions such as there should not be any partner living at the time of the marriage after the commencement of this act, obviously. And it lays down conditions as to age of the bride and the bridegroom. In case of bride, it is 18 years, and in case of bridegroom, it is 21 years. It also lays down condition as to mental fitness, so that it is ensured that parties have made a reasoned decision before taking such a drastic step which can affect their lives. Then, two essential conditions which are mentioned in section number 5 are related to prohibited degrees and Sapinda relationships. Now, all these conditions, they are going to be subject matter of a different class. We need to discuss them in detail separately. Um, However, we'll be referring to section number 7 in details. Section number 7 actually talks about ceremonies. Right? Section number 7 आपको ceremonies के बारे में बताता है. But for a valid marriage, mind you, for a valid marriage, both of these sections are to be satisfied. So let's just see what Section 7 actually provides. Yes, Section 7, as you can see, it is titled as Ceremonies for a Hindu Marriage. A Hindu marriage, it says, a Hindu marriage may be solemnized in accordance with customary rites and ceremonies of either party thereto. Either party thereto. Now, let's read subsection 2 also, and then we will analyze. Where such rites and ceremonies include sapadi, where such rites and ceremonies they include sapadi, that is taking on of 7 steps by the bridegroom and the bride jointly before the sacred fire. This I have told you. The marriage becomes complete and binding with the seventh step taken. This we have already understood, right? Complete and binding. Let's analyze these two subsections. Subsection 1. A Hindu marriage may be solemnized. First of all, this word may should not be viewed as something making it an optional for the parties to marriage to undergo ceremonies, right? It indicates that if you want to get married, you have to solemnize it in accordance with the customary rites and ceremonies, right? It is not giving you an option to do or not to do it. In case you want to do it, you have to observe the customary rites and ceremonies, right? So may is actually referring to the option of getting married or not. It is not referring to the ceremonies of marriage. Be mindful about that. So a Hindu marriage may be solemnized. Now, this word solemnized, it simply means that it needs to be celebrated. It needs to be celebrated in the appropriate form as directed by the customary rites and ceremonies, right? So solemnized word, please remember this. It means that the marriage needs to be celebrated. A party can satisfy all the conditions of Section 5. The other party might also satisfy all the conditions of Section 5, right? Which I referred to earlier. But if the marriage between them is not celebrated as per the rites and ceremonies, then that marriage will not be a valid marriage in the eyes of the law, right? वो valid marriage नहीं मानी जाएगी. So it has to be celebrated. But celebrated in accordance with the customary rites of ceremonies of whom? Then Section 7 says it has to be celebrated as per the customary rites and ceremonies of either party there too. So either the bride's customs can be followed or the groom's customs or ceremonies can be followed. That option Section 7 gives. So here, Section 7 actually is recognizing a very important fact that Hindu society, as a whole, if we analyze Hindu society, we see variations in ceremonies and rites also. Some people believe that a ceremony A is essential for a valid marriage. Some people in the Hindu society they believe that ceremony B is essential to be conducted in case a person gets wants to get married, right? So there is a variation. So Section 7 says that okay, we recognize this variation. The law has recognized this variation. We are not obligating any particular ceremony to be performed. We are not forcing you to perform any kind of ceremony, right? You are free from our side, but the ceremonies are to be performed. That must has to be satisfied. So ceremonies of either party, this liberty has been provided considering the heterogeneity of ceremonies and customary rites within the Hindu society, right? So either party ceremonies can be followed. Then regarding Sapadi also, in subsection 2, we have seen that it has not put an obligation on the parties that Sapadi has to be mandatorily followed. It has to be mandatorily performed by the parties. It simply says that Sapadi, wherever necessary, it needs to be performed. When subsection 1 and subsection 2, they are read together, it simply indicates that Sapadi, if it is the essential ceremony related to the party whose ceremonies and customs are being followed to solemnize the marriage, then Saptapadi has to be performed. Otherwise, Section 7 does not mandate performance of Saptapadi for a valid Hindu marriage. Right? And then it also lays down the effect of Saptapadi, how it takes effect. It becomes complete and binding. The marriage becomes complete and binding the moment seventh step is taken, right? So it is actually prescribing, not prescribing any particular ceremony, including Satpadi. It is providing you the meaning of Satpadi. It is providing you the option to go by the ceremonies and customary rites of either party. If that custom or ceremony requires Sappadi to be followed, then it has to be followed mandatorily, not otherwise. And effect of Sappadi will be what? The moment you take the seventh step, the moment you complete seven steps, the marriage becomes complete and binding. Right? That is all section 7 says to you. Right? Now coming back to this, right? We have seen that it must be solemnized. We have understood that solemnized means here that it needs to be celebrated in accordance with customary rites and ceremonies of at least one of the parties there too. Please remember this, right? Sometimes in the preliminary examination, they ask you कि भाई किसके custom और ceremonies के हिसाब से marriage होनी चाहिए, and the options will be provided something like this, that it is the bride's customs that are to be followed, it is the groom's ceremonies that are to be followed, it is the option can also indicate that the ceremonies and rites of both the parties are to be followed. You must remember that the act prescribes, section 7 simply says that customs and ceremonies of either party. Please remember this, right? Solemnize to celebrate, this has been covered already, right? Does the act prescribe any essential ceremony to be performed? We have understood this already, right? It does not prescribe any particular ceremony. It only mandates that ceremonies are to be followed. Ceremonies are to be performed in their correct form, right? और किसके applicable होने चाहिए वो custom or usage as to the either party. That's it. So it nowhere prescribes any particular kind of ceremony. It nowhere prescribes sappati to be essential part of the ceremonies, right? We have seen this. However, we are again and again saying that customary rites and ceremonies of the parties are to be followed, right? The custom has to fulfill the essential conditions, certain essential criterias. Now, these criterias are part of the general law as well, and the same has been provided. The criteria has been provided in section number 3, which is the definition clause of Hindu Marriage Act. Let's see. Let's see section number 3. Just give me a second. Yeah. Yes, so I was telling you that the criteria for a valid custom, it is prescribed also under the definition, defining section of Hindu Marriage Act. Section 3, Clause A, it says that the expression custom and usage signify any rule which having been continuously, one criteria is that has to be continuous and uniformly observed for a long time. Second criteria is there has to be uniformity in its observation. Third, for a long time, it indicates that the custom needs to be an antique custom. It has to be long enough to be followed uniformly and continuously by various generations. Has obtained the force of law among Hindus, right? The force of law has to be there. It should not be something from which the Hindus can deviate from, right? It should have the force of law. Then the custom can be a local area custom. It can be applicable only to a particular tribe, community, group, or even a family. A particular family can have its own customs, right? If these criteria are fulfilled, a family can also say that this particular custom is followed in our family with respect to marriage. That will also be recognized. What else? Then there are two provisos. First proviso says that the rule is certain, so certainty is another essential that we get from the proviso. It should be reasonable. Here it is written, it should not be unreasonable. So I'm saying it should be reasonable, and it should not be opposed to public policy. Public policy means it should not be opposed to the policy of the law at any point of time, and it should not be against the moral standards of the society. Then second proviso says, provided further that in the case of a rule applicable only to a family, it has not been discontinued by the family. Now, however, the second proviso was not at all necessary, because here you are prescribing one of the conditions to be continuous, right? The custom has to continue. It has to be continuously and uniformly followed. So, even in the absence of proviso 2, we need to establish that there was no discontinuance in observing the custom, right? So all these essentials have to be satisfied. Now, custom has to be seen that it is a kind of fact which is to be brought before the court, which is to be pleaded. It has to be in your pleadings. You have to give evidences to prove the same. And proving a custom can be, you can approach it from different aspects. You can either provide the testimonies to the court, you can provide documentary evidences, you can provide the judgments where such a custom was recognized already. And sometimes the court can also take judicial notice of the custom where the custom was repeatedly established in other cases, and where it has been discussed at length in various books, right, of celebrated authors. So अगर judicial notice court ले लिया, then you need not prove it. The burden of proving otherwise will be on the other party. So that's how the proving part is taken care of. Now, moving further, so all these essentials have to be satisfied for a valid custom. Moving further, now we deal with the effect of non-performance. I have already told you in brief previously that if section 7 is not satisfied, right, section 5 and 7, they are to be read together for a valid Hindu marriage. So if section 7 is not satisfied, that is, ceremonies are not performed in terms of section 7, they are not performed in the form that they are required to be performed, then it will definitely have an effect on the validity of a marriage. Such a marriage will have no value in the eyes of the law. So marriage, in case of non performance of the ceremonies, the marriage will not be considered as valid. It will have no value in the eyes of the law. Now, with this, we need to discuss also the doctrine of factum valid. This particular doctrine, it emphasizes the substance of a thing over its form. It says that if something is there in its substance, it does not matter whatever form you give it, right? We must recognize it. But in case of performance of ceremonies, you cannot say that particular couple has been living as husband and wife together, and in substance they are husband and wife, they are partners in everything, right? So we must recognize their relationship. So doctrine of factum valid has limited application in case of ceremonies of marriage. We cannot say that in substance the relationship is looking like the marriage, a valid marriage. So we must take it as a valid marriage. The doctrine of factum valid is not applicable. However, it can be applicable in case of observance of non-obligatory ceremonies. As I have told you that broadly you can classify ceremonies into mandatory ones and the non-mandatory ones, obligatory ones and the non-obligatory ones. So in case of non-obligatory ones, which otherwise also cannot impact the validity of marriage as such, right? There can be application or doctrine of factum valid, but not in case of the essential ceremonies. So non-observance of essential ceremonies cannot be overlooked by applying this doctrine. Please remember this, right? Substance over form. It is one of the doctrines of equity, right? तो substance over form, ये आप ceremonies के context में नहीं लगा सकते हो. If it is proved that ceremonies were not duly followed, they were not duly performed, then non-observance cannot be ignored by application of doctrine of factum valid. Okay. Now we have a very important case of Bhaurao versus state of Maharashtra. This case has been part of many preliminary examinations. They ask you in which case it was held that ceremonies of Hindu marriage are essential for a valid Hindu marriage, right? So it was Bhaurao versus state of Maharashtra. You can come across when you solve PYQs, right? So what happened in this particular case? Mr. Bhaurao, his full name was Bhaurao Shankar Lokhande. Mr. Bhaurao, he was already married with in Dubai, in Dubai. And during the lifetime of in Dubai, again gets married to one Kamla Bai in the year 1962. So in the year 1962, it means that now the parties will be regulated by the Act of 1955, Hindu Marriage Act 1955. Now, Hindu Marriage Act 1955 prescribes monogamous marriages. There has to be monogamy. Now, bigamy or polygamy has been very clearly prohibited under the Act of 1955. So they could not get married in the lifetime of Hindu Bai, Kamlabai and Bhaurao. They cannot get married, but still they went ahead and um, it was proved through testimonies that actually no ceremonies were performed that were applicable in the community of these parties. And it was only by way of exchange of garlands that the marriage was actually solemnized. So, what happened? The first wife and her relatives, they initiated a criminal proceedings against Bhaurao and Kamlabai and several others for bigamy. So section 17, let's have a look at section 17 of Hindu Marriage Act. It takes you to IPC. Let me just show. Yes, section 17. Punishment for bigamy. It says that any marriage between two Hindus solemnized. Here also the word used is solemnized. Solemnized after the commencement of this act is void. First, it declares the second marriage or the third marriage. Any marriage after the first marriage during the lifetime of the partner, it declares it to be void. Right. First thing is this: if at the date of such marriage either party had husband or wife, okay, living, and the provisions of sections 494 and 495 of IPC shall apply accordingly. Right? These provisions they pertain to offense of bigamy. So it takes you to IPC. First, it declares that the marriage will be void marriage, right? If it is solemnized during the lifetime of the partner, be it husband or wife, right? If it is solemnized during the lifetime of the partner, then the marriage will be void and it also becomes punishable under the relevant provisions of Indian Penal Code, right? So the proceedings were initiated. Now, interestingly, defense from Bhaurao's side has pleaded that the second marriage was not solemnized. And since the word solemnized is used in section 17, it was not solemnized in the sense of section 7. And since section 17 uses the word solemnized, so the second marriage has to be a valid one. Then only section 17 will become applicable and declare it void and make it punishable, right? So what happened? At the initial stages, all of them were released by the magistrate court. Only the Bhaura was punished. He was convicted and he raised an appeal before the district and sessions judge. His appeal was rejected. Then he made a revision petition before the Bombay High Court. It was also rejected. And finally, he came and knocked the doors of Honorable Supreme Court. And before the Supreme Court, all these arguments were made. So naturally, the court had to go into the essential ceremonies related to the parties and interpretation of section 7 and section 17 together, right? So the court found that the second marriage between Bhaurao and Kamlabai was actually in the nature of a Gandharv marriage, Gandharv form of marriage. Now, Gandharv form of marriage basically means it is a love marriage where the um, grand celebration of the marriage is not at all required to be done, right? It can be done through performance of simple rituals. But it was indicated before the Supreme Court that even the performance of Gandhar form of marriage, it requires two things to be done. First is invocation before the sacred fire, right? This we saw that it is one of the essential ceremonies for Hindu marriage, and Sakpadi was also applicable uh, on these parties, even in case of Gandhar form of marriage. But as I have said earlier, that they have not performed any such ceremony. They just simply exchanged the garlands and they went their homes happily that now they are married. So all these facts were proved through testimonies, and commentary of Mullah on Hindu law was also referred to the court. And Mullah also says that even in case of Gandha form of marriage, these two things are to be performed, and there was no evidence from the prosecution side in case they were the respondents. No evidences were there which can show that these ceremonies were not applicable in case of Gandharv form of marriage, and Gandharv form of marriage can also be performed through exchange of garlands. This evidence was not there, so the court said that the second marriage was not solemnized properly in the sense of section 7, and section 17 also uses the word solemnize. This we have already seen, right? Again I'll show you. See, section 17 also uses the word solemnized. So since it was not solemnized in the sense of section 7, section 17 cannot be made applicable. It declares something void which actually would have been valid. And since ceremonies were not performed, the marriage was not solemnized, the marriage was simply not valid. And as such, the section 17 is not required for any purposes. So naturally, when section 17 is not applicable, the court said that um, there was no second marriage was not valid marriage, and Bhaurao had to be acquitted. So these are the implications of ceremonies that are required to be performed, right? Sometimes they work against you, sometimes they work for your advantage. uh, Now let me address the second aspect of today's class, that is the registration of Hindu marriage. For this we need to refer to section number 8 of HMA. Section number 8. Let's see what section number 8 says. It provides for registration of Hindu marriages, right? Let's read it and then we will see what are the essentials of section 8. It says, for the purpose of facilitating the proof of Hindu marriage, the state government may make rules providing that parties to any such marriage may have the particulars relating to the marriage entered in such manner so and so. Right? That is, the latter part is not relevant. Subsection 1 indicates that what is the purpose of registration. The purpose of registration is that it actually facilitates the proof of the factum of marriage. Right? It helps in proving the marriage wherever it is disputed, wherever the validity of marriage is disputed, the registration can act as a proof. Right? So it is for that purposes only. And for such purpose, Section 8 actually says it gives a discretion to the state governments. Right? State governments are empowered to make rules, right? If they deem it necessary, if they deem it fit. So a discretion is given to the state government to have rules on registration of marriages, and a discretion is also given to them that they can also make these registrations to be compulsory, right? It is provided in subsection 2. Let's see. So notwithstanding anything contained in subsection 1, the state government may, again the word used is may, if it is of the opinion that it is necessary and expedient so to do, it can provide that particular so and so shall be compulsory in the state, right? So compulsion is also on the discretion of the state government, right? So a state government can completely do away with the registrations. They can, I'm talking only about Section 8. We'll see what is the exact position now, right? So as per Section 8, the state can take one view or the other. It can either decide to prescribe for registrations of marriages, it can decide not to prescribe. And if it prescribes, then it can keep it either as an optional thing or a compulsory thing. It is completely on the uh, discretion of the state governments as per Section 8, right? Section 8 के हिसाब से ये है. Then the last subsection is relevant for us, notwithstanding anything contained in this section, which means none of the provisions they become applicable when the issue is of validity. So nothing contained here in section number 8 will affect the validity of Hindu marriage. It says the validity of any Hindu marriage shall in no way be affected by the omission to make the entry, right? So three important things are laid down in section 8. First, it empowers the state government to prescribe rules for registration. Second, it gives discretion to the state government also in terms of making such registration mandatory or optional. Third, it says that registration in no way will come and affect the validity of the marriage. So if the essentials mentioned in section number 5 and section number 7 they are satisfied, and the parties they did not get their marriage to be registered as per the provisions of section 8 read with the rules made by state government, it will nowhere affect the validity of such marriage if they can prove that they were free to get married under section number 5, and also they have performed the ceremonies as contemplated by section number 7, right? So their marriage, the validity of their marriage will not be affected in any manner under section number 10, right? Sorry, under section number 8. However, section number 8 does not deal with one situation. To that situation I'll come later. Let's first discuss the status of registration of Hindu marriages now. So, what happened? There was a case which was before the Supreme Court, Srimati Seema versus Ashwini Kumar. Again, a very important case from prelims perspective. Also, it happened in 2006, right? It was before the Supreme Court. In this case, the Supreme Court was acquainted with the state of affairs with respect to registration of marriages. It examined the position under various states, where some of the states they made it mandatory, where some of the states made it optional, and there were other states where no rules were prescribed, where no rules were laid down concerning registration of marriages. So, in order to bring uniformity, the Supreme Court in this case ordered that the states and the center they must come up with a policy where registrations have to be mandatory affair. And why it did so, it was done to ensure that women their rights are safeguarded, because one of the treaties, that is elimination of any kind of discrimination against the women, um, India is a signatory to that, and that treaty prescribes that registration of marriages has to be a mandatory thing. So court took note of that, though India made reservations to that particular provision. But after having taken note of the problems that arise due to non-registration of marriages, it can affect women. It can also affect the victims of child marriages. And then through registration, we can also counter the practices of bigamy and um, all sorts of things where registration can act as a deterrent on the party, right? So all these things were considered and weighed by the court, and they observed that registration would aid in preventing child marriages, ensuring minimum marriage age, and combating the evils of bigamy and marriage without कंसेंट, राइट? सो जब रजिस्ट्रेशन कराने के लिए आप किसी को बोल देते हो तो वैसे फिर आदमी घबराता है कि नहीं, अब सब कुछ एज पर लॉ करना है, सब कुछ ठीक से करना है, राइट? सो जस्टिस पसायत वाज the author of the judgment, and he uh, directed all the states and the central government that you must come up with the policy within 3 months and ensure that the registration rules are framed after considering the public objections. This is the one of the steps involved in coming up with the policy, that it is usually communicated to the public first, and objections are sought. So court also said that such an exercise has to be done. Then it has to be made. a mandatory thing, and there must be consequences for non-registration or false declaration in the registration process, right? The court also said कि rules में भी ये बात लिखनी लिखी होनी चाहिए, although section 177 of IPC, and I think it has now become section 210 of PNS. It has become section 210 of BNS. If I'm not wrong, you have to check it. But as far as I can recollect, it is 210. It prescribes punishments for giving wrong informations to the public servants. So 177 was already there in place, but the court got it right that it should be part of the rules as well. Right? So we have seen that registration under HMA, it is not at all mandatory. What is the object of registration? It facilitates proof of the factum of marriage. But though it is not mandatory under Section 8, what has happened after Seema versus Ashwini Kumar? Supreme Court has directed the states to make it mandatory, and now every state follows the same thing, right? Okay. Effect of non-registration. This has to be addressed in two subparts. One subpart I have already discussed with you. Second मैंने कहा था कि मैं later आपसे discuss करूंगा. One is that non-registration does not affect the validity of marriage. This we have seen. The last subsection of section number 8 clearly prescribes it. But what about those marriages which are registered under section number 8 and the rules made there under, uh, right? They are registered, the parties are living together, and now the dispute arises, and it is said that the ceremonies were not followed, or the parties um, were not eligible to get married to each other as per section number 5. What will be the effect? So section 8 tells you that non-registration will not affect the validity of marriage. But what about a marriage which was registered, but section 5 or section 7 or both were not complied with? Will we recognize such a marriage? The answer is no. Answer is no, because the entirety of discussion that we had so far, it clearly indicates that it is the ceremonies is something that they are not negotiable thing. They are to be followed, because marriage is not only about the wining and dining or songs and dance. It is a very serious affair, and it has spiritual and social functions in the society. And here I'm reminded of one of the senior professors whom I had the privilege to interact with. He's Professor V.K. Dikshit. He was earlier with Delhi University, and then he was with the National Law University, Bhopal. He has taught very fantastic subjects. Though I was never taught by him, but we were in touch somehow. We are still in touch, and he has been the person who was also responsible for training judges, not only from India, but also some of the countries in the South Asian region. So judges, they come to India and get trained, and Bhopal Judicial Academy, that is National Judicial Academy, which is in Bhopal. So he used to get invited to train them. So he used to say to me always, and he still says whenever he gets the opportunity, that Rohit, marriage is a very serious business. And considering the discussion that we had, yes, it is indeed a very serious business. So we must approach it with some seriousness. It is not only about dining, it is not only about wining, it is not only about songs and dance. It is not a commercial transaction where you see that there is an opportunity to get dressed, to dance, and to exchange gifts and to take dowry through pressures and all sorts of things, right? It has very serious connotations. So section 5 and 6, they section 5 and 7, they are non-negotiable, even if the marriage is registered. But section 5 and 7, they are not complied with. The ceremonies are not performed duly, then the registration will not give the marriage a valid color, right? And in this regard, we have a very recent case from the Honorable Supreme Court. It was decided recently in the last few weeks of 2024. Dolly Rani versus Manish Kumar Chanchal, 2024 Supreme Court. So let me just quickly tell you what were the facts, and then we will be able to appreciate what the court had to say in this particular case. So in this case, what happened? Both the parties to marriage, that is Dolly Rani and Manish Kumar Chanchal, they were the trained commercial pilots. So Manish was from Bihar and Dolly was from Jharkhand, but both of them were residing in uh, Ghaziabad. Though this fact is not provided in the judgment when I was reading it, but it is my guess because the registration it happened in UP. So the only way the registration could have happened in UP is they being the residents of Delhi NCR, part of Ghaziabad, right? Um, I'm just making an intelligent guess here. So the boy was from Bihar, the girl was from Jharkhand, she was from Ranchi, boy was from Muzaffarpur, and the marriage was registered under the UP registration of marriage rules. So what happened? They um, got engaged in March 2021. And for the purposes of registration, it was shown that they got married in July 2021. But actually, the marriage it didn't happen, and the families they mutually decided that the marriage is going to happen in October 2022. So they got themselves registered as a married couple in July 2021, though the marriage had to take place in October 2022, right? So naturally there were no ceremonies that were performed. So what happened in the meantime, from between July 2021 to October 2022, the relationship got strained by some issues between them, and the girl initiated several criminal proceedings against the family members and the boy. She alleged that they were demanding dowry from the girl's family. And consequently, what happened? Manish initiated proceedings for divorce in the family courts of Muzaffarpur in Bihar. So actually, this was a transfer petition before the Supreme Court, where the girl asked the Supreme Court to transfer the petition that was pending before the family court in Muzaffarpur to transfer it to Ranchi, Jharkhand, where she was currently residing. And ultimately, this transfer petition converted into a proceeding under Article 142 of the Constitution, to which I have referred in one of the previous lectures of mine. And when the transfer petition was pending before the court, both the parties they made a joint application before the Supreme Court under Article 142 and asked the court to make a declaration that the marriage between them, as contemplated for the purposes of obtaining registration, it is not a valid marriage because ceremonies were not performed. And as part of their mutual understanding, they are ready to just put an end to every single piece of litigation that is pending before them. So court took note of these facts and also the application under 142, and it analyzed sections 7 and 8 together, and it highlighted the importance of ceremonies first. Everything that we have discussed so far, वही सेम चीजें कोर्ट ने भी बोली सेरेमनीज के रिगार्डिंग, that validity of marriage it depends on the performance of the ceremonies, either the brides or the bridegrooms. Then the court also analyzed section number 8. It says that though registration is not mandatory under 8, now we have rules, and even if registration is obtained under the relevant provisions, that the marriage is has complied with all the relevant sections and it is a valid marriage. Such a certificate, such a registration will not give the color of validity to the marriage. And in the absence of ceremonies, the marriage is not valid. It has to be declared void. It is void actually, and the certificate cannot prevent that effect from taking place, right? So after analyzing all these things, the facts and the provisions of section number 7 and 8, the court came to the conclusion that okay, we declare they were not married at all, and they have decided, mutually decided कि अपनी जो भी litigation pending है वो सब कुछ they will put an end to it. So, in coming to the judgment, arriving at the conclusion, the court highlighted that the marriage certificate was baseless without the actual performance of the ceremonies, right? And the justices also put an emphasis that marriage is a sacrament in Hindu culture. This we have already discussed, right? It is a sacrament, it has some sacred value, right? The requirement of co-participation in religious and social obligations of the husband and wife, this very fact, it takes the marriage to a level where it is treated as a sacrament. It is treated as one of the sanskars under Hindu culture, right? It is a sacrament in Hindu culture, which is the foundation to societal and familial structures. The court made such observations, right? So naturally, the court invalidated the marriage certificate first and directed the marriage registration that happened in the under the UP registration rules of 2017, right, to be declared to be nullified. Okay. So, this was all about the ceremonies and registration of marriages under Hindu Marriage Act. But before I end today's session, I would like to show one of the beautifully worded paragraphs from this judgment, right, where the court is talking about the nature of marriage. I have highlighted this for you, and for everybody's benefit, I think I should read it aloud. Here, the court says that we further observe that a Hindu marriage is a sacrament and has a sacred character. In the context of Sapadi, in a Hindu marriage, according to Rigved, here it is talking about those situations where Sapadi is relevant for the customary rites and ceremonies of the parties. So, in the context of Sapadi in a Hindu marriage, according to Rigved, after completing the seventh step, the bridegroom says to his bride, now it is saying, it is highlighting what actually happens after Sappadi. The bridegroom says to the bride, with seven steps, we have become friends. That is Sakha. May I attain to friendship with thee, which means with you. May I not be separated from thy friendship. May I not be separated from your friendship. So a wife is considered to be a half of oneself, that is Ardhangini, but to be accepted with an identity of her own and to be a co-equal partner in the marriage. There is nothing, the court makes a very interesting observation here. Please pay attention. There is nothing like a better half in a marriage, but the spouses are equal halves in a marriage. In Hindu law, as already noted, marriage is a sacrament or a sanskar. It is the foundation of a new family, right? So there is no concept of better half. There is a concept of equal halves in the marriage. That is the relevance of the ceremonies and doing the marriage with proper ceremonies and giving or giving it a serious thought or approaching it with some seriousness, right? If you do not take these seven steps consciously, mind you, you might end up taking millions of steps in the courts, right? So it is better to take the less number of steps, seven steps, with the mindfulness, than regretting it later and taking endless steps before the courts in case the dispute arises, right? So here the court has also said that the parties, they are equal halves in the marriage. So on that note, I uh, request you to follow this piece of advice from the Honorable Supreme Court and decide which half will have the remote control, and maybe it is mutually decided that remote control will be shifted depending on the situation and depending on the time frame, whatever suits you or whatever sails your boat. But do treat each other with equality and do approach the thought or the decision of marriage with utter seriousness, right? Otherwise, it will be very problematic, not only for you but also for the family members, and if there are any children involved, then their interests will also be definitely affected. So with this, we can end this session, I believe, and I will be happy to take your doubts now. And meanwhile, you type your doubts in the comment box. Let me just tell you that Now I am inviting you to explore our course that we have designed for judicial services examination preparation. We have taken a very long time to discuss what should be there, what should not be there. So we have curated a syllabus, a course which can be beneficial for everybody. It does not matter from which state you belong. It does not matter whether you want to practice or you want to give it a try at a later stage. It does not matter uh, whether you want to approach the higher judicial services examination. However, the course is designed keeping in mind the uh, I should not use this word, but for want of better words, the subordinate judiciary. But it will be equally helpful for higher judicial services examination also, because ultimately the basics, they are going to be the same, whatever exam or whatever case you approach, right? So do check our course, and I sincerely believe that Livelaw Academy can be your Sakha in this journey. So, no doubts, no doubts. Okay, wonderful, wonderful. It seems that everything is clear to everybody, and it gives me immense happiness that you people do not have doubt after attending these sessions. These sessions. Sutantra is here again. Hello, Sutantra. It is always good to see you in every session. I think we should wait for another minute in case anybody has any doubt. Then we can wind up. So, my only piece of advice is to approach the marriage as well as examination with seriousness. Okay, nobody has any doubts. Okay, wonderful. I'll see you in the next session. Till then, take good care of yourself. Continue reading law. Continue improving on daily basis. Best of luck. Thank you.
From the New York Times.